All right, so part two, we're dealing with defective contracts already. So please be familiar with the following. What are the statuses of contracts? It can be valid, it can be void, voidable, rescissible, unenforceable, or inexistent. So to be familiar with, um, a contract is valid when all the elements necessary for it is present. Consent, object, and consideration is being present. Okay, so absence of any of them, void. However, there is some particular defects which may cause it to be voidable, rescissible, or unenforceable. Let's go with rescissible contracts. What is a rescissible contract? Those which have caused a particular economic damage either through one of the parties or to a third person, which may be set aside even if it is valid. So technically, all the elements are there, but the consequences of its provision will then entail economic damage to either or a third party involved. So to that extent, the damage is to be relieved or to remedy. Which contracts are rescissible? So here, one that is entered into by a person who is what? Exercising fiduciary capacity. So those are entered by guardians whenever the ward suffers damage of more than 1/4 of the value of the property or 25%. So if you would recall, there is what we call now lesion or the economic damage that is being caused. Notice that this is one entered into by a guardian in behalf of the ward. So if I am the administrator of your property, I sell the property at a very low cost or a very low sum amount, then it will prejudice you. That is why even if the consent, the object, or the consideration are all present, the consequence therein for the said contract will then be considered as a factor for one to consider that this is to be rescissible or to rescind, to annul, or to cancel such contract. Another form is that there's an agreed upon in representation of the absentees if the absentee suffers lesion by more than, again, 1/4 of the property value. Contracts where rescission is based on fraud committed on the creditor. Which contracts are rescissible? Again, continuation, objects of litigation, wherein the contract entered into by the defendant without knowledge or approval of the litigants or the judicial authority. Example of these, usually wherein the property is still subject to be determined who is its rightful owner, and then apparently the one who's in possession of it will eventually sell the property with all the valid cost, object, consideration. It's just that the consent or the judicial approval or authority has not been validly claimed. So there can be a rescission there. Payment by an insolvent on debts which are not yet due, it will prejudice the others. And in various instances provided for by law under 1526, 1534, 38, 39, 42, 56, 60, 67, and 69. Later on, we'll try to identify most of them. So what contracts are rescissible? The second category would be in the state of insolvency. So plaintiff has no other means to maintain reparation. So the plaintiff may be able to return whatever he may have obliged to return due to rescission. And there must not, the things must not have been passed to a third person in good faith, and it should be within 4 years of the instance wherein one is in the transaction is being made or contemplated. So what are the requisites before a contract entered into fraud of creditors may be rescinded? So here are your considerations. There must be a credit existing prior to the celebration of the contract. Before we entered into a contract, there's already utang involved. and there must be fraud or at least the intent to commit fraud, which will prejudice the creditor for the one seeking rescission. Meaning, I am one of your creditors, may kolektahon ko dapat sa imo, and then ginapawalaan mo. You then try to evade it by selling the property to some other individual to which the profits you are intend to keep and evading my right over your property to claim, then that would fall under the second requisite. The creditor cannot in any legal manner collect his credit, subsidiary character of the rescission, meaning it has made the creditor desperate to claim for the said object or the said property. The object of the contract must not be legally in possession of a third person who acquired it in good faith. Now, complete distinction between Article 1191 and Article 1381. 1381 is rescission, 1191 is resolution. So both presupposes contracts that are validly entered into and subsisting, and both require mutual restitution whenever they are proper. So the nature in resolution is that the principal action is retaliatory in character, or it is the main action that you would want to do. Whereas in rescission, it is a subsidiary remedy after everything else. Say, for instance, if you were not going to validate such contract and all, what you would want is to realize that there is economic loss available therein. So there is this remedy to rescind the contract. So the grounds of rescission, the only ground provided for in 1191 is the non-performance of an obligation. Whereas the grounds for rescission, there are 5 grounds as earlier enumerated, such as lesion or economic damage, fraud of creditors, and non-performance is not important here. Again, the basis of rescission is the fraudulent act to escape your creditors or you're suffering from economic, what we call, damage. In resolution, it applies only to reciprocal obligations, meaning one party is bound to perform from the other, and the other is also required to perform something for the other. Meaning, at some point, I am a creditor to the other party where I can demand from him or her the delivery of something. And then on the other hand, the debtor that I have to another object, say for instance, the delivery of the money. I am the debtor for the delivery of the house. I am the creditor for the delivery of the money. So again, the reciprocal obligation is that there is, in this instance in 1191, both active and passive subject into different identities of the party. Okay? So again, say for instance, I'm going to deliver the title of the property. And then on the other side, his requirement is to give me the money. Kaya mo nang na-agreehan. So that's the reciprocal obligation. Whereas in rescission, it could either be unilateral or just one party, and it can also be reciprocal obligation. So persons who can initiate the action, only the injured party who is the party to the contract. Whereas in rescission, even third person that has been prejudiced by the transaction can ask or initiate the action. Sino yung third person? The creditors. They were not the original parties to the sale of the certain property, but because they can prove that the seller is actually selling the properties he have in order to escape their liability, then they can assert and insert the provision on rescission. Others, nga third person, it can be someone who is in possession of the item and he is in good faith. Pwede man the ward or the minor child at the point wherein they eventually regain full status or acting upon a different custodian or guardian. So the fixing of period by the court, this is to be given in resolution. Court may fix a period or grant extension of the time fulfillment, whereas in rescission, the court cannot grant extension of time. The purpose, cancellation of the contract, here, reparation of the damage or the injury. Okay? Resolution is more or less the what we would consider as the annulment proper of the return, the objects or the proceeds or anything that has been exchanged of. While in rescission, your intention is for the reparation of the damage or to the injury. You just simply return the particular less of the value or return the particular objects which supposed to be is intended or reserved for the creditors. Note, while Article 1191 uses the term rescission, the original term used in the Old Civil Code is resolution. That's why 1191 is known as resolution proper. What is the obligation created by rescission of the contract? A mutual restitution of things which are the objects of the contract and their fruits, and the price with its interest are to be restored. Mutual restitution. Iuli mo ang na-receive ko, iuli ko, ang na-receive mo, iuli mo sa akon. So, when is mutual restitution not applicable? Say for instance, when the creditor did not receive anything from the contract, or the thing is already in the possession of a third person who acquired it in good faith, subject to indemnity only if there are two or more alienations liable for the first infractor. So rescission is possible only when the person demanding rescission can return whatever he may be obliged to restore. So a court of equity will not rescind the contract unless there is restitution and that the parties are restored to the status ante. These are problems. Skip that. So what are the badges of fraud attending the sales as determined by the court? Here are badges of fraud. Considerations or conveyance is inadequate or fictitious. So badges of fraud meaning these are indicators that there is fraudulent transaction causing economic damage, indicating that it can be disadvantageous to the creditor. It can be an indication that there is this possible ground for rescission. So the consideration or conveyance is inadequate or being fictitious. I-transfer ko lang sa imo nga ngalan so that hindi ni malagas sa akon nga creditors. Transfer be made by the debtor after a suit has begun and while it is still pending against the debtor. So sale upon credit by an insolvent debtor. So ging baligya niya pero utang lang. Wala transaction pa. Wala pa bayad. So ipautang niya pero he has no capacity at that point for sustenance. Do wala ka na gani may mabuhi sa lawas mo, ipautang mo pa ang mga ginabaligya mo. So that can be an indicator. So the presence of evidence of large indebtedness or complete insolvency of the debtor, transfer of all his property by the debtor when he is financially embarrassed or insolvent. And transfer is made between the father and son when there are present some or above circumstances. Failure of the vendee to take exclusive possession of the property involved. So these are indicators that determine whether there is actually fraud being conducted. What are the characteristics of the right to rescind? So here, they can demand only if the plaintiff is ready, willing, and able to comply with his own obligation, and the defendant is not. In instances, again, reparation means kaliwaan, restore mo kung anong nakuha ko simo, iuli ko ang nakahatag ko simo. By the grounds that there might be lesion or economic damage, or there might be an instance wherein this is a fraudulent transaction. Another character here is that it's not absolute. It needs judicial approval in the absence of stipulation, allowing extrajudicial rescission in cases of non-reciprocal obligations, subject to judicial review if availed of extrajudicially, and may be waived expressly or impliedly. And the last one is implied to exist in reciprocal obligations, therefore need not be expressly stipulated upon. So these are just mere the characteristics that you can find to whether one has the right to rescind. I have the right to rescind so long as I know, ma-apply ko nga, pwede ko yung mauli ang nabaton ko. Okay? Next, may an injured party avail of both fulfillment and rescission as remedy. As a general rule, the injured party can only choose between the two of them, only one, the rescission or the fulfillment of the obligation. He cannot have both. Note, this applies only when the obligation is even possible for fulfillment. If, for instance, if fulfillment has become impossible, your civil code allows the injured party to seek rescission even if he has chosen fulfillment. That is forming part of the exception under 1191. Okay? So again, general rule, only choose one. If gimpili ko yung attorney is fulfillment, but technically the fulfillment of it cannot be performed or has been rendered impossible. So what will you do? Ipa-rescind ko na lang. Iuli ko na lang. Bawi. Okay. All right. Problems. Problem again. What is the prescriptive period for an action to rescind? Within 4 years from the time the termination of the incapacity of the ward, meaning the ward has become 18 years old, kung minor siya, or the ward becomes, say for instance, regains his sanity, or basta anything that will now capacitate the ward within 4 years. Under 1381 number 2, within 4 years from the time the domicile of the absentee is known. Absentee. Okay, usually may mga husbands or wives or parents, they are missing, gone missing for a certain number of years. Then a period of 4 years would be the prescriptive period for the absentees. In number 3 and number 4, within 4 years from the time of the discovery of fraud. 1381. Let's go to voidable contracts. What are the characteristics of a voidable contract? It is effective until you try to set it aside. Just like in voidable marriages, diba? Valid until it is being annulled. It may be assailed or attacked only in an action specifically for that purpose. That is to attack the contract, that it is voidable. Can be confirmed. Can be assailed only by the party whose consent was defective or his heirs or assigns. When is there a voidable contract? One of the parties is incapacitated to give consent. Consent was vitiated. So incapacity and vitiated consent affects the contract and it causes it to be voidable. Who are the persons incapacitated to give consent? The deaf mutes who do not know how to read and write, or even the illiterates. Persons who are insane or demented person, unless they contracted it during their lucid interval. Minors are incapacitated to give consent. There are certain exceptions when they're trying to enter for their contract of necessaries. When contracts by their guardian or their legal representative and the court gave its judicial approval, minors can enter. When there is an active misrepresentation on the part of the minor. The minor is now estopped. He appears to be older than 21 years old or older than 18, looking kay mature siya, but in reality he's only 14. Advanced ang iyang aging physically. Contracts of deposit with the postal savings bank, provided that the minor is over 7 years of age. And then upon reaching the age of majority, they would ratify their action. What are the different vices of consent? This is very important because, again, this would then affect consent. This is supposed to have been taken during the element of consent, but ara na siya discuss. What are vices of consent? Mistake. Mistake must refer to a substantial mistake and not merely an accident or mistake. They refer to the substance of the thing, which is the subject of the contract. And they may also refer to those conditions which have principally moved one or both of the parties to enter into a contract. Note that the mistake as to the identity or qualifications of one of the parties, this will vitiate consent only when such the identity or qualifications have been the principal cause of the contract. So very important that the mistake must be substantial. Okay. Would you have purchased it had you known that it is not the thing? Oh, di ba? Intimidation. It is the internal moral force operating in the will and inducing performance of an act. Violence. It's an external, serious, irresistible physical force exerted upon a person to prevent him from doing something or to compel him to do an act. What about undue influence? Any means employed upon a party which under the circumstance could not have been resisted or has the effect of controlling his volition, inducing him to give his consent to the contract which otherwise he would not have entered into. Undue influence. Somebody that usually provides that. Fraud, the use of insidious words or machinations in inducing another party to enter into the contract which without them he would not have agreed upon. So mistake, intimidation, just to note that intimidation, internal moral force na siya. Violence, external, serious, irresistible physical force. Undue influence naman niya. These are items of which, what? They affect or control. There's a volition, there's an inducement to gain the consent. Fraud naman niya, you are utilizing certain words, machinations, pretensions of anything to other party so that you would gain their agreement or favor. So what are the different kinds of mistake? Mistake of fact and mistake of law. When one or both of the contracting parties believe that the fact exists when in reality it does not, then such fact does not exist when in reality it does. Mistake of law naman niya, when one or both of the parties arrive at an erroneous conclusion or interpretation of a question of law or legal effects of a certain act or transaction. Again, mistake of fact, both parties believing that this is particularly true, but in reality, it does not, or they believe that it does not, but in reality it does, then particularly it will be considered as a mistake of fact. Mistake of law, more on an erroneous conclusion, that you do not particularly understand the legal consequence of the laws on that particular transaction. Mistake as a vice of consent refers to mistake of facts and not of law. Okay? Mistake of vice of consent, as to the vice of consent, they refer to the facts and not of law. But the exception is when mistake of law involves error as to the effects of an agreement when the real purpose of the party is being frustrated. So to determine the effect of an error, both the objective and the subjective aspects of the case, which is the intellectual capacity of the person who committed the mistake. All right? Self-explanatory. So when will mistake invalidate consent? This is the very important question. Okay, di ba? Consent is to be performed or to be gained. You need to have what element of the consent? Consent must be unconditional, complete, definite, with intention. All right. So when does it invalidate your consent? Through mistake. In order to invalidate consent, it should refer to the substance of the thing, which is the object of the contract, or to those conditions which have principally moved one or both of the parties into the contract. So, substance of the thing. Example. Note, there are contracts where consent is given by mistake or because of violence, intimidation, undue influence, or fraud. They are effectuating voidability, creates voidable contracts. These circumstances are defects of the will, the existence of which impairs what? The freedom, intelligence, spontaneity, the voluntariness of the party in giving consent to such agreement. Okay? Very important. And so, Article 1332 was intended to improve what? Intended to improve the protection of a party to a contract who was disadvantaged by illiteracy, ignorance, mental weakness, or some sort of handicap. So it contemplates a situation wherein a contract is entered into, but the consent of one of the contracting parties is vitiated by mistake, fraud, or committed by the other. Okay? So protection, yun ni siya. What are the requisites that ignorance or erroneous interpretation of law or mistake of law will vitiate consent? So mistake must be with respect to the legal effect of the agreement. It must be mutual. The real purpose of the parties must have been frustrated. Wala na achieve. Okay, say for instance, you're buying all of this and then technically you would note that the interpretation is that it's not illegal to acquire it in bulk, in whole, in everything, and then gali, it's being prohibited. The substance is being identified as one of those found in the drugs. So there can be a mistake or interpretation of the provision of the law. Excuse me. What are the requisites of intimidation? One of the parties is compelled to give his consent by a reasonable and well-grounded fear or an evil. The evil must be imminent and grave. It must be unjust. The evil must be the determining cause for the party upon whom it is employed in entering into the contract. Okay? So intimidation, again, it speaks of what is being founded in the mind. Fear that is being created there. Violence naman niya, external. It must be serious or irresistible and determining cause for the party upon it is to be considered as one who is employing it in the contract. Now, what are the different kinds of fraud? Here, fraud in the perfection of the contract. Fraud in what we consider as causal fraud, dolo causante. Incidental fraud, fraud in the performance of technically, incident lang galit, line na yan. Incidental fraud, fraud while you are performing the obligation. Sila. Yeah, no, sakto. Fraud in the performance of an obligation is different from incidental fraud, causal fraud, and then fraud in the perfection. So how is this going to be different? Okay, here's an illustration. Okay, so let's look at fraud as a deceit, means of deceit using words, machinations, or anything that designed to fool or provide deceit. Say for instance, I'm selling to you cell phone. Cell phone happens to be one that I would identify as iPhone 13 Pro. And you agreed to buy it in the price that I told you. Causal fraud is, say for instance, ang fraud ko is that these are technically not iPhones. It's just that I created the logo, I just made it my own. This is not officially a product of Apple. So the cost of you entering into the contract with me is already fraudulent, to which you would not have given me your consent. Incidental fraud naman niya is that this is actually a iPhone, but this is not a brand new iPhone. Fraud in the performance of my obligation is that in delivering this to you, I claim that this is not owned by me. Okay. I'm just claiming that it was owned by me, but technically it was not owned by me. So there is what we call still deceit. And in delivering this to you, there are defects. It is confirmed that it is an iPhone. It is confirmed that this is a brand new iPhone. It is confirmed that it is my iPhone. But in perfecting my obligation, there is fraud in there because the item that I'm going to sell you technically is not an iPhone that is being produced in a particular manufacturing area. So for instance, I would claim that this is just made in China, an iPhone. You know, there's a lot of counterfeit for that. So these are levels of fraud. Causal fraud, from the very start, ginainto ka na nga hindi na siya gali amo na ang product. Incidental fraud, amo na, idulong ko ang product si mo, galing kay may depekto, may kakulangan, sinada. Fraud in the performance of the obligation, say for instance, as to the volume that you're trying to deliver, instead of 100 sacks of rice, what you are doing is that you're delivering 100 sacks, but they are underweight. Some of them, like 10 of them, it's not 50 kilos, but only 48 kilos. So those can be instances of fraud in the performance of the obligation, performance in the perfection of the obligation. Fraud in the performance of an obligation, as an example is here. Fraud, insidious words or machination must have been employed by one of the contracting parties. It must be serious. It induced the other party to enter into a contract. Should not have been employed by both of the contracting parties or by a third person. So dolo cansante versus dolo incidente. Cansante is the very root. From the very start, he is fooling you. Refers to a fraud which is serious in character. Incidente, not serious in character. It is the cause which induces the party to enter into a contract. So the representations I've made, this helped you determine to enter into that contract. Incidente, it is not the cause which induces you to enter into a contract, but merely incidental lang. Again, baka mo nagyapon sang bugas. So, baklon ko. Pero ang incident sinada is that the quality of that rice is not the same as what I wanted, but I still needed the rice. Incidental. Renders the contract voidable. Okay? For dolo causante. Voidable. And here, there is pagpanginto sa performance, you can ask for damages. Kasi giinto ya ka sa performance. Ask for damages. So note, in contracts, the kind of fraud that will vitiate consent is one, through insidious words or machinations of one of the contracting parties. The other is induced to enter into a contract. Because again, because it's a consent, the consent is being procured by a fraudulent manner. Your consent is you're being deceived to give the consent. So without them, he would not have agreed. This is known as dolo causante or the causal fraud, which is basically a deception employed by one party prior to or simultaneous to the contractor in order to secure the consent from the other. Okay, that's a problem. What are causes of extinction of action to annul? Sige. So instances wherein you need to be aware causes of extinction of action to annul, there is prescription, ratification, loss of the very thing. So in prescription, the action must be commenced within 4 years from the time the incapacity ends, guardianship ceases, violence, intimidation also has ceased. Mistake of fraud has also ceased. So meaning to say, kung ikaw, ang consent mo was being procured by fraud, upon your discovery of such fraud or upon such mistake, you will then need to file an action against that other person. If not, you have already lost your right through prescription. Ratification. It cleanses the contract of its defect from the moment it was constituted. So kabalo kang amo ni bala in marriages. You know that you were defrauded for something, and yet upon its discovery, you continue to cohabitate for that certain period. So you have been ratified. The term ratification is that you have cleared or cured its defect, knowing that even if it exists, you wanted to make sure that it still happens or it's still preserved. So there must be knowledge to the reason which renders it voidable. Such reason has already ceased, and then the injured party must have executed acts expressly or impliedly to convey that you are trying to waive whatever it is that will cause you to ask for its rescission or cause you to act for its annulment. So by the loss of the thing, which is also a cause for extinguishment of obligation, which is the object of the contract, through fraud or fraud of the person who is entitled to annul the contract. Okay? Who may institute action for annulment? By all who are obliged principally or subsidiarily in the obligation. He who has the capacity to contract may not invoke the incapacity of the other party with whom he has contracted, simply because third person who is a stranger to the contract cannot institute an action for an annulment. Okay, what are the effects of annulment? If a contract has not yet been consummated, the parties shall be released from their obligation arising therefrom. But what if the contract has already been consummated? The rules that you will follow is under 1398 to 1402. So what is confirmation? We'll go back to 1398 and 1492 later. What is confirmation? It is an act by which a voidable contract is cured by its vices or defect. What is recognition? It is an act wherein the defect or proof is cured, such as an oral contract is put into writing when a private instrument is converted into a public instrument. So what is ratification? Please take note of all these terms. It is an act by which the contract entered into in behalf of another without or in excess of authority or curing its defect. Okay. Modes of ratification, express or implied for statute of frauds. If both parties are incapacitated, ratification by their guardians or their parent shall validate the contract retroactively. For expressly or implied, that is for statute of frauds. Again, for both parties who are incapacitated, their guardians or their parents may do that in their behalf. Sige. Let's end here muna.